The U.S. Supreme Court conference today. We could know Monday whether or not they're going to take a gun ban challenge that's originated out of Cook County, Illinois, in the city of Chicago. Welcome in. It's Illinois in Focus Daily. I'm Greg Bishop, editor of thecentersquare.com, Illinois. So go check out the Illinois page and get the latest headlines in your inbox, and you can click on newsletter and find out more. All right, so a couple of cases, actually, that the U.S. Supreme Court is considering here concerning gun control laws. You've got the Viramontes case, which they are expected to talk about in conference today. In that case, coming all the way back in 2022, an individual suing Cook County over that county's gun and magazine ban. But then when Illinois banned firearms across the states that were semi-automatic and different types of accoutrements and magazines over certain capacities, and requiring a registry of those who already had those firearms grandfathered in, that law passing, and then Viramontes wrapped that into their lawsuit. But the case, the district courts, the court siding with the state and the county, and the appeals courts, the court siding with the state and the county, didn't really have as thorough of a record as some may have wanted. But that case, the Viramontes case, is now in front of the U.S. Supreme Court, and they had it in conference several weeks ago before the holiday, but there was no report issued for it. So meaning it's been sent back to conference. And you can see here on the U.S. Supreme Court's docket page exactly that progress here, right? I mean, it was filed to have a writ of certs from the U.S. Supreme Court August 27th. They had motions to extend responses, but then it was distributed to conference for December 5th. And then it was distributed to conference a second time for December 12th. And now we see it here distributed for conference for today. So we could know Monday whether or not they're going to take that Viramontes case. Now, something else to consider, too, is another case that they are going to consider is the case that made it all the way through the federal judiciary, challenging the ban on firearm possession on mass transit. So Illinois, you can't take, even if you have a concealed carry license, you cannot take your concealed carry firearm with you onto mass transit. And Schoenthal litigants, the plaintiffs in these cases, they took it to the courts. The district court sided with the plaintiffs, saying that this does infringe on their constitutional rights. And if you recall, this particular case in the federal district court, after that ruling, there was a shooting on a CTA line and a murder, and the prosecutors filed documents looking for appeal to essentially signify that the judge, saying that the law's unconstitutional, could have led to this type of shooting. The judge wasn't having that. Brought the defense attorneys in from the Cook County and state and chastised them in open court. It was via a conference call, but regardless, chastised them and then still proceeded. So the court case then went to the appeals court. Appeals court sided with the state. And now you've got the U.S. Supreme Court that's actually asking for responses, signifying that they are going to take this case. So this is the Supreme Court docket for the Schoenthal v. Raoul and the state of Illinois. Petition filed on Halloween. You have the distribution to conference on December 10th. And then they asked for a response. So December 17th, they are asking for a response, and that response is due by the 16th. But there was a motion to extend that response deadline. So that's been filed, and the motion to extend the time for filing a response is granted, and the time's extended to February 17th. So we're not going to know anything about the Schoenthal case and the next steps in the U.S. Supreme Court in that case until February 17th. So all of this, of course, a lot of people are going to be watching closely. I mean, I know in Illinois, at least, we're still waiting on the Barnett case, which is the case out of the Southern District of Illinois that had a 4-day bench trial and thousands of pages of testimony and evidence that was compiled, a very strong record from many people's opinions. In the district court, that judge found it unconstitutional. It's now in the appeals court. They sat on it for months. Even though the law was deemed unconstitutional, it was still in effect. And the appeals court not doing anything with it, urged by the plaintiffs to get on with it. They're in limbo right now. We have a judge saying it's unconstitutional, but the appeals court's just sitting on it. Then the appeals court put out the hearing date that was heard last year. We were still waiting on the appeals court to issue a ruling in that case. Now, are they waiting to see what the Supreme Court does with Viramontes, right? A case with not as strong of a record. If the Supreme Court says we're not going to take that case, officially states that, are we going to get the ruling out of the appeals court that would then elevate that Barnett case with the strong record to the U.S. Supreme Court? Again, it's still a lot unclear here. One individual who's involved in a lot of these cases, including the Viramontes case and so on, is Alan Gottlieb from the Second Amendment Foundation, and the Center Square reporters touched base with him about a week and a half ago to talk in general about the Supreme Court handling these types of cases.
They've decided to hear cases, involving marijuana users who are being denied being able to get permits to carry or being able to purchase a firearm because you can't be a drug user on the federal forms that you have to sign to be able to purchase a firearm at a licensed dealer. They've already taken that case with that to hear. And then Hawaii, of course, we call it the vampire rule. Hawaii passed the law that says you can't carry a firearm or bring a firearm onto private property, period, unless the owner of the property or the restaurant establishment gives you permission ahead of time to do it. And they've taken that case as well. And we're engaged in that one with an amicus brief. So there's two cases they've already chosen to hear. And there's a bunch more on their plate dealing with various things from 18 to 20-year-olds being young adults being able to purchase or get permits to carry a firearm. Other sensitive places cases, so-called assault weapon ban cases and magazine capacity ban cases, restoration of rights cases for people who committed minor nonviolent felonies. There's a whole lot more percolating that they're already petitioned for cert to the Supreme Court.
So a lot of cases, again, that we're going to be keeping an eye on, and you can, of course, stay with us here and the Center Square as we give you a lay of the land and at least help you understand why it's taking so long for some of these cases to percolate up to the U.S. Supreme Court. All right, so Monday, be with us. We'll be here live with Illinois in Focus Daily for 8:30 in the morning ish. Whenever the U.S. Supreme Court's expected to issue their orders list, 9:30 Eastern Time. 8:30 our time, so we should be live at that time, and I know a lot of people in the chat room will probably already be pulling that up and refreshing that orders list page to see exactly what happens. So appreciate you guys out there joining us each and every weekday morning here with Illinois in Focus Daily and the Center Square.